Good morning, sir. Can you see and hear me? I think you may be on mute.
Yeah, I can hear you. That's fine.
Thank you very much. Can I call Mr. Dilley, please?
Yeah.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Can you give your full name, please?
Stephen John Dilley.
Mr. Dilley, you should have in front of you a very lengthy witness statement, 194 pages in total. Could I ask you to have a look at page 178, which should have a signature? Yes, is that signature yours?
Yes, it is.
And is that statement dated the 8th of June 2023, true to the best of your knowledge and belief?
Yes, it is, save for 3 points I wish to draw to the inquiry's attention.
And what are those?
Can we turn to paragraph 130, please?
Yes.
In paragraph 130, I talk about a letter that I sent to BDO Stoy Hayward on the 22nd of August 2006. That was a letter to which the inquiry directed me at question 24 of 49 in its Rule 9 request. I subsequently talk about a draft accountancy report that BDO prepared. When you read paragraph 130 and subsequent paragraphs, you may conclude that it was that letter of the 22nd of August that led to the draft accountancy report. In fact, there was a very similar letter of the 22nd of August to which the inquiry has not put to me, but I sent to the inquiry and I know that they have it. They had it from Post Office, that led to the draft accountancy report. So I would not wish to create the impression that it was that particular letter that led to it.
Thank you. Is that the only amendment you'd like to make?
No. Can we turn to paragraphs 357 and 358? In paragraph 357 of my statement, I talk about a meeting with Andrew Wise on the 14th of June 2006. And I talk about the agenda of the meeting, which I produced to the inquiry. At paragraph 358, I talk about an attendance note of that meeting. And at paragraph 359, I quote from the note. That meeting note is not exhibited to my statement, and that is my error, for which I apologise to the inquiry. We've sent it to the inquiry, who already had it, so they're aware of that. But I wish to draw it to your attention.
Is there one more? Or?
There's just a final point. When I reread this statement, which, as you say, is 194 paragraphs and with all the exhibits comes to over 1,700 pages in these 3-4 lever arch folders, the impression that that can create is that this is a statement entirely from my memory. It isn't. When I got the Rule 9 request in, I think it was April, I looked down the request and I looked at the questions. And this was a case that this October I took on about 18 years ago. And I looked at the questions and I thought, I don't know that one. I don't know that one. I don't know that one. I do know that one. I do know that one. I don't know that one. So I could have given a very, very short statement to the inquiry that's largely said, I don't remember. I didn't think that would be helpful because we're here to learn. I thought what would be a more helpful approach is to go through the information to which the inquiry directed me, plus more documents from my firm's file, to be able to reconstruct the story for you and to make it easy. And that's what I have done. And I've said as such in my witness statement, but I don't want to create the impression that the process of doing that helped me remember it. But I don't want to create the impression that it's all been from my original memory. It hasn't been.
Thank you very much. That witness statement has the unique reference number WITN 04660100. That will be published in due course, and it will be on the inquiry's website available to the public. Mr. Dilley, you are currently a solicitor and partner at Womble Bond Dickinson, is that correct?
Yes.
And Womble Bond Dickinson was at the relevant time known as Bond Pierce.
That's correct.
And you had conduct of the case of Mr. Lee Castleton.
Yes, I did.
You've clearly reflected a lot on the contents of your witness statement. And before we begin, having reflected on the evidence of the inquiry as a whole, is there anything that you would like to say to Mr. Castleton or to his family?
No, there isn't.
Do you consider that you bear some responsibility for what happened to Mr. Castleton?
In what way?
Well, there's nothing you wish to say to him. Is that because you consider that this case was conducted appropriately?
I have been asked in this statement whether I would do anything differently in this case. And now might be a good time to turn to that part of this statement, because that contains my evidence on this subject.
I'll take you to the statement in due course, but I'm asking you a question about anything you'd like to say to Mr. Castleton, and your answer is no. And my question for you today is whether you consider that you bear any responsibility for what happened to Mr. Castleton in the conduct of the case, in the way that the case was conducted by yourself.
I'm satisfied that I acted and my firm acted professionally and politely and appropriately at all times.
I'd like to look at your statement. Can we get up on screen, please? WITN 04660100. Thank you very much. Can we look at scroll down to page 4, please? From page 4 onwards, for the next few pages, there is a summary of events leading up to the litigation as you've described it. Can we please look at paragraph 13, which is on the next page? Thank you. You describe there at paragraph 13 evidence that Helen Rose gave in her statement to the court in the Lee Castleton case. And if we scroll down, there is a large paragraph, paragraph 15, which quotes from paragraph 9 of that statement.
Yes, that's right.
And that reads as follows. The inspection revealed that the safe was left open, the safe keys were left in the safe door, and it was not secured, that cash and stock were not secured at lunchtime if the sub-postmaster was not on the premises, that travellers' checks were not kept in the safe, and foreign currency was not held securely, that standard procedures for adjusting losses and gains were not adhered to because losses were unauthorised, and personal checks on hand had been incorrectly treated. However, I should add that I believe the reason Mr. Castleton was subsequently suspended was because the Marine Drive branch was short of significant amounts of cash rather than because of the control gaps that the security inspection identified. That paragraph there takes up approximately a third of that summary of events leading up to the litigation. Did you include that paragraph in this witness statement to suggest in some way that Mr. Castleton was sloppy or slapdash?
I included that paragraph to reflect the evidence given to me in not one, but 2 witness statements of Helen Rose in the case. And that was the evidence that was contained in her statement. I have read our note of the trial, and one thing I think she may say in her, either in her statement or in our note of the trial, is that the security checks that she started to do were not finished. They became overtaken by events. So I wouldn't want to suggest that was completed.
Indeed, there was a paragraph before that paragraph in her witness statement that explained that those checks had not been completed. And did you hear her evidence to the inquiry that she said that that was simply incorrect, that paragraph?
I didn't hear that part of her evidence to the inquiry, no.
Why is it so prominent in your summary of the events? Why did you select that paragraph in particular?
Because that was her evidence. That was her evidence to me at the time, contained in 2 witness statements.
Can you see, it doesn't make Mr. Castleton look very good, does it? The suggestion that in some way he left the safe open, for example.
What Helen Rose said is not my evidence, that's her evidence.
But you've included in your evidence.
Yes.
And you've
yeah.
selected from her
Yeah.
witness statement 2 specific paragraphs.
I
and
have.
included that quite prominently.
It's a short statement that she made. Paragraph 9 is longer than paragraph 5, and so it would come across as more prominently because it is longer. But the really important thing from Helen's statement, in my view, the really important thing was the fact that the audit involved physically counting, and that's a shorter paragraph, which gives it shorter to say, physically counting cash and stock at the Marine Drive branch. And in the process of her counting, and she had an assistant, it was somebody called, I'm going to say someone like Chris Taylor. She had an assistant, and in the process of counting the physical cash and stock, she found that there was insufficient cash. That's the really important point from her statement.
So why include paragraph 9?
Because it's part of her statement. That's what she said in her statement that she found.
Let's look at her statement. It's poll 000711196. This is the second witness statement.
Mm-hmm.
And can we turn over the page, please? Page 2. So there are a number of paragraphs before paragraph 9, and if we look at paragraph 8, she says there, as part of a normal audit, we have to complete a procedural security inspection. Mm-hmm. This was initiated by my colleague, Chris Taylor. When a postmaster is suspended, then any remaining compliance tests are not completed because the large number of compliance tests, including security compliance, that have to be completed for each audit. Accordingly, although the procedural security inspection was started as a matter of routine, I do not recall it being completed because Mr. Castleton was suspended prior to its completion and then became irrelevant. You didn't include that paragraph in your statement for this inquiry, did you?
No, I have not.
No, and it was paragraph 9 that you included, which Ms. Rose has told the inquiry should not have been included because it didn't happen. It was not correct.
That's not... but, you know, her evidence to the inquiry has been either yesterday or the day before. My statement was produced in June.
Yes. Absolutely. I'm not suggesting that you knew what she was going to tell the inquiry, but it's quite a significant paragraph in your witness statement to this inquiry. Do you accept that that paragraph, paragraph 9, is highly prejudicial against Mr. Castleton?
I think it is prejudicial. Yes, I do. But if you look at paragraph 8, my understanding from what she was saying in that, and she may have from the evidence she's given to the inquiry, she may say that effectively I'm wrong. But my understanding from what she was saying is that the security check had been started. The issues that she'd found are at paragraph 9, but the security check hadn't been finished.
In fact, her evidence to the inquiry was that list of safe was left open, safe keys left in the safe door was simply a checklist that hadn't been completed. Did you hear that evidence?
I did not.
If we scroll down, please, staying with that paragraph 9, but over to the next page. In the last sentence there, she says, however, I should add that I believe the reason Mr. Castleton was subsequently suspended was because the Marine Drive branch was short of a significant amount of cash rather than because of the control gaps that the security inspection identified.
Yes.
Its purpose, therefore, was not to prove the case against Mr. Castleton of that paragraph. Is that fair?
That is fair.
And in fact, its purpose is simply to prejudice against Mr. Castleton.
I think the control gaps which I had understood her to have identified through the incomplete security report may have begun to offer an explanation to what happened to the cash. One thing I was clear about at the time, and I'm clear about today, is I did not think that Mr. Castleton had been dishonest.
And the impression given by paragraph 9 is one of a sloppy postmaster, is it?
That's the impression that I take from that. It says that travellers' checks were not kept in the safe, that they were not held securely, that standard procedures for adjusting losses and gains were not adhered to, but because losses were unauthorised. I mean, I'm surprised that she has resolved from that, because it is correct that in Mr. Castleton's case, that process wasn't adhered to. Losses were unauthorised.
Well, that's one very short part of that paragraph, but the significant passages that relate to the safe being left open, the safe keys, etc. I mean, the impression that's given in your witness statement is that this is a neat legal case about whether somebody signed or didn't sign accounts. What I'd like to understand is actually the relevance of any of that, even if it were true, to the case that was being brought against Mr. Castleton.
I think it offers, or may offer, but not if Helen Rose doesn't support it, but it may begin to give some alternative insight into what happened to the money.
Putting to one side that significant evidence that, in fact, Mr. Rose says was incorrect, more broadly, do you consider that the case was conducted by yourself, that was conducted by yourself, was intended to make an example of Mr. Castleton?
I think that question really goes to Post Office's motives in this case, Post Office's state of mind. And I have said in this statement, and I believe it today, I don't think there was one single consistent motive that dominated throughout the entire life of this case. I think when the claim was first issued, it was issued to pursue what Post Office believed was a debt. However, as the case continued, I think the motivation of Post Office changed, and what they wanted out of the case changed. I think it was less about making an example of Mr. Castleton and more about sending a message that they were willing to defend the Fujitsu Horizon system.
Do you see a significant distinction in making an example of Mr. Castleton by setting a legal precedent and defending the Horizon system?
This case had the potential to set a new legal precedent. It had the potential to become a test case, but ultimately it didn't. It just reconfirmed old law.
Well, it did say some significant things about the Horizon system, though, didn't it?
In Mr. Castleton's branch, it did.
Mr. Castleton's evidence to this inquiry was that you said that the post office would ruin him. Did that happen?
I do not believe that it did, no.
Well, I'd like to look at some documents which show the general approach that was taken over the course of those proceedings. Can we look at it? LCAS 0000535, please. This is the original claim form, so we're starting on the 9th of June 2005. If we scroll down, we'll see the statement of claim on the next page, or the page after, page 3. And if we look at paragraph 7, that's at the bottom of page 4. You have there the sum that is said to be owed, and paragraph 7 says, such loss and the defendant's failure to account for it could not have occurred without the defendant's negligence, carelessness or error, and or the action or inaction of the defendant's assistants. If we now turn to the defence, poll 00082222, page 2 of that. This is the defence and counterclaim of the 15th of August 2005. If we could scroll down. Thank you, and over to the next page. It's here that Mr. Castleton raises issues with the Horizon system. He says the defendant repeatedly sought assistance from his managers within the claimant company during the period over which the apparent shortfall accumulated. No assistance was forthcoming. The defendant avers that any apparent shortfall is entirely the product of problems with the Horizon computer and accounting system used by the claimant. Could we scroll down, please, to the counterclaim? Mr. Castleton then brings a counterclaim, and at paragraph 9, he says the defendant avers that the claimant wrongfully terminated the defendant's contract as a sub-postmaster following his suspension, and that the true cause of the apparent shortfall is the accounts of Marine Drive Post Office, is the claimant's own computer system, not any misconduct or negligence on the part of the defendant or his assistant. The Horizon accounting system is at the core of Mr. Castleton's case. Do you accept that?
I accept that absolutely that Mr. Castleton made allegations about the computer system. But a really important point is Post Office succeeded in its claim in spite of the computer system. It succeeded in its claim on the basis of physical accounting records.
Well, we'll get to that in due course, but in terms of the case that he is bringing, so his defence, his counterclaim, Horizon is front and centre.
That's correct.
Let's look at how this was dealt with, bearing in mind the allegation that you said to Mr. Castleton that the Post Office will ruin him, an allegation that you deny. Let's look at poll 000-72669. So we're starting now 24th of February 2006, so early 2006. This is an attendance note following, I think, a conversation between yourself and Mandy Talbot, who was the Post Office legal case manager. Is that right?
For the majority of the case, that's right.
It says that I had a telephone conversation with Mandy Talbot. Internally, the Post Office feels conflicted about which direction to go with the Castleton case. The Post Office believes the Horizon system is robust, but the downside is the cost in Post Office's time and money in proving a negative, i.e. there are no faults, and that is expensive. For example, Mandy would need to get a report from Fujitsu, who apparently have difficulty writing in plain English, and get someone in the Post Office to review Fujitsu data to see if there are any anomalies. And this is the significant passage that I'd like to take you to, although I will return to that first paragraph. It says there, it is Mandy's view that the Post Office must not show any weaknesses. And even if this case will cost a lot, there are broader issues at stake than just the Castleton claim. If the Post Office are seen to compromise on Castleton, then the whole system will come crashing down, i.e. it will egg on other sub-postmasters to issue speculative claims. Mandy knows that Mr. Castleton is talking to Bargee, the other sub-postmaster, bringing a Horizon-based claim. The Post Office's clear line to the industry must be that we are to take a firm line with Castleton. She even said that she thought it might be damaging to settle the claim on confidential terms rather than fight it and lose it. I put to you earlier about Mr. Castleton being made an example of. I mean, does that not give you the impression that the Post Office was seeking to make an example of him?
We're looking at this now, some 17, 18 years later. But the advantage that I do have is that I was there at the time. Mr. Castleton will see this completely understandably, this point about being about him. But really what Mandy was saying is Post Office wanted to show that they were willing to defend the system. In fact, this talk about their motivation is in some ways irrelevant. Because once the claim had been issued, and once the counterclaim had been issued, which for most of the time was put at £250,000, Post Office had no choice. Post Office could not simply discontinue their claim without having to deal with the counterclaim. And Post Office tried many times to settle with Mr. Castleton. I think in that paragraph, I think that's a reference to Mr. Bargeage, and there's a typographical error in how that's been spelt. So the way I understood it, it wasn't, and Mr. Castleton will feel this, of course he will, but it wasn't about making a personal example of him. It was about sending a message that they were willing to defend the system against somebody pursuing them for a large counterclaim.
Irrespective of the personal effect on Mr. Castleton. Do you agree with that?
Can you put the whole question together for me?
I mean, it was quite short. Your suggestion is that it wasn't about him, but it was certainly irrespective of the personal impact on Mr. Castleton, and in knowledge of.
I think they were cognizant of the personal impact on Mr. Castleton, and they didn't want to go to trial. They wanted to settle.
Well, that's not what the last sentence there says. It says she even said that she thought it might be damaging to settle the claim on confidential terms rather than fight it and lose it.
That was Mandy's thought, and she, as you'll have seen from my attendance notes, she says things that are eminently quotable. But you have to look at the actions where they tried to settle, because actions speak louder than words, and they tried on multiple occasions, and I've set out a table in this statement that it would illustrate my point if we were able to find it. They tried on multiple occasions to settle this case.
But looking at the 24th of January 2006 at least, so relatively early stages of this litigation, it certainly seems as far as Mandy Talbot was concerned, that the case shouldn't be settled and that Mr. Castleton should effectively be sacrificed in order to prevent further challenges against the Horizon system. Do you agree with that?
No, I don't.
Okay, well, let's look at more contemporaneous documents as time goes on. Let's look at the 7th of March 2006. That's Pol 000708882. If we could start at page 2 of this document, and halfway down, it's an email from yourself to Mandy Talbot. And you say, "Dear Mandy," and I'm looking in particular at the final paragraph there, "is there any tactical preference for getting Castleton tried before Bajaj or the other way round? It sounds as though Bajaj has not issued a claim yet, so presumably it would be helpful to have a favourable judgment on Castleton ASAP before Bajaj goes to trial, if either of them get that far." And let's look at the...
Please, can you just scroll up so I can see the date on that?
Absolutely. That is the 7th of March 2006.
Yeah.
And then if we scroll up further, we can see her response. Thank you. She says there, Bajaj has not as yet issued proceedings, so tactically a decision on Castleton, or better still, Castleton disappearing, would be advantageous.
Mm-hmm.
Let's look at the...
And I take Castleton disappearing to mean Castleton settling. And I can give you the context of that on page 107 of my statement.
We don't need to turn up your statement. Perhaps you can tell us why you think that provides context.
Because these emails need to be set in the context in which we were operating. On the 7th of November 2005, I was instructed by Mandy Talbot, just before then, to offer a mediation to see if the claim can be settled, and we did. On the 8th of November, Mr. Castleton's solicitor replied and said he would only mediate after disclosure. On the 17th of November, on behalf of the Post Office, we urged Mr. Castleton to reconsider his position on mediation. On the 5th of January, with the blessing of Mandy Talbot, we made an offer pursuant to Part 36 of the Civil Procedure Rules to try to settle the claim.
Can I stop you there? Is the point that you're trying to make that throughout the Post Office were trying to settle the claim?
Absolutely.
Okay. I'll continue with these emails. Can we look at Pol 000708824, please? It's over the page, thank you. This is an email from yourself to Mandy Talbot. We're now on the 24th of April 2006. I'll go chronologically throughout April, June, August. Assets. And then we have the final paragraph that's currently on the page. Thank you. You say there, "Dear Mandy," and you address the issue of Mr. Castleton's assets. And you say there is a bigger picture, i.e. that the Post Office wishes to be seen to be taking this claim very seriously to defend the Horizon system and to discourage other sub-postmasters from pursuing similar claims. However, looking at the case in isolation, the cost-benefit of pursuing it to trial, even if you succeed, is uncertain. That bigger picture being to dissuade other sub-postmasters from bringing Horizon-based claims.
Yes, and that goes to the point that I've been seeking to make. They were trying to show that they were willing to defend the Horizon system.
But not willing to, as we'll see in due course, disclose very much material relating to the Horizon system.
Well, I'm really happy to be taken through disclosure.
Thank you. We'll get to that shortly. Can we look at Pol 000711165? We're now on the 6th of June 2006. This is an attendance note. It has Adrian Bratt's name. Who was Adrian Bratt?
He was a solicitor at Bond Pierce. I think at the time he was probably a trainee.
Thank you. In attendance was yourself, somebody called Married Hughes, some people from Fujitsu. So we have Anne Chambers there, for example, Gareth Jenkins, and others.
That should say Andy Dunks.
Andy Dunks. Oh, yes, thank you. If we look at the first substantive paragraph under the Horizon disputes, we have the meeting opened with SJD, I think that's yourself,
Yes.
introducing the agenda and outlining the Castleton case. You were outlining the post office's point of view with regards to settlement, and that they're very keen not to set a precedent, and they would like to take the firm line, thus giving a clear signal such that the accounting system is okay and they do not want to be taken for a ride. You think that you will struggle to settle this case. And then there's a reference to two other cases, Bajaj and Bilku.
Yes.
So at that stage, it was clear to you that there were other cases in the pipeline relating to the Horizon system.
Yes, there were two other cases, those of Mr. Bajaj and Bilku.
Thank you. If we move forward to August 2006, can we look at poll 000711088? This is an attendance note, a telephone attendance note from yourself, 18th of August, in the Castleton case, and it refers to a telephone conversation you had with Cheryl Woodward. Do you remember who Cheryl Woodward was?
Distantly, the Cheryl Woodward was the person who I think first instructed my firm to issue the claim. She was based in Chesterfield in the, I think, what was known as the former Agents Debts team. So she worked in the business. I didn't understand her to be in the legal team.
Okay. You summarised the claim and the defence to her, and I'm just going to read this paragraph. It says, explaining that what initially started as a debt recovery matter has now turned into a much broader point given the Horizon-type defence of Mr. Castleton, and that Post Office Legal considered that if they are seen to settle this case or walk away, then that will open the floodgates for lots of other sub-postmasters' claims, given that they are all talking to each other on blogging websites. However, explaining to her the costs, given 7 to 10 days in court and 10 or more witnesses, could well be £200,000 or £300,000. Accordingly, if you look at the case in isolation, it is completely nonsensical, especially given that Mr. Castleton's asset position suggests that he would be unable to pay. However, the Post Office have taken a broader view. That is it not entirely consistent with the suggestion that Mr. Castleton would be ruined if the case went ahead?
Can you take me, please, if we're going to talk about Mr. Castleton being ruined, to the attendance notes of the calls I'd had with him in November 2006? Look, I entirely accept that insofar as we could understand Mr. Castleton's asset position, there was a significant risk that he would be unable to pay. He did take out insurance, and at one point I wrote to his solicitors and said, you haven't served a notice on us because prior to the Jackson reforms in 2013, if you took out an insurance policy, if it was an after-the-event insurance policy, you were required to serve a notice. And the fact that I wrote that letter suggests to me that at one point we didn't know if it was an after-the-event insurance policy, which if it was, and we'd have succeeded, could have potentially paid some or all of our costs, or before the event insurance policy, and we weren't sure how much it was for. Nevertheless, I entirely accept that we had advised Post Office more than once that it was a serious risk that if they succeeded in their case against Mr. Castleton, that he would be unable to pay all of their claim.
We're going chronologically, so we may well come to November. If we don't, then you can have an opportunity over lunch to identify the particular document that you'd like to bring to the
I
Chair's
think
attention.
I think it gives really important context to the point that you're trying to make.
Well, we have, as at the 18th of August 2006, a clear suggestion that Mr. Castleton would be unable to pay any costs against him.
That is correct.
And we also have the very fact that at the end of the trial, Mr. Castleton was unable to pay the costs against him.
That is also correct.
So it would have been clear to the Post Office that the effect of this litigation would, in effect, be to ruin him.
Whether that is correct or not, I refute using that language. And I'm happy to take you to the contemporaneous attendance note of the calls, notes of the calls that I had with Mr. Castleton about that.
So is your evidence that if you had said that you would ruin him, you would have made a clear note of that and put it on your case file?
Well, two things on the ruin comment. First of all, it just doesn't sound like, I know myself, it just doesn't sound like language I would use. It just doesn't sound at all like something I would say. It makes me sound like a Vinnie Jones character from an East End gangster film. It's just not at all who I am. But the second, that's sort of knowing myself. But the second point, really, to be able to address this question, I think it'd be really helpful to go to the contemporaneous attendance notes. Those contemporaneous attendance notes were only made for me. I'm the only audience. There is one note, not a note I'm talking about, where I talk about a call or a letter to BDO. And what gets typed up is video. These notes aren't written for anybody else. You've already spotted a typographical error in one. They're written for myself, and they were dictated after the call. So
is your evidence that you would have written it down had you said it?
yes.
I mean,
And more than that, in the that's part of it, and the contemporaneous note shows that language wasn't used. But also, if we could, to answer the question, if we please get the note on screen that I've made of the call in November, it doesn't fit with the other part of the note, the tone of the note, in which I said to Mr. Castleton, I think it was probably for the first time that I'd said that to him because he started acting in person. I said to Mr. Castleton, look, I didn't need to say this, but I believed it, and I still believe it. I said to him, I don't think you've been dishonest. And I believe that today. I don't think he dishonestly took money from Post Office. And I think, and I hope it will give him some comfort for me to confirm that to this inquiry. I said it to him at the time. Our barrister, it can be seen from the transcript of the, our note of the written note of the hearing. Our barrister said it at the end of the case. I disavow any allegations of dishonesty. It was not in our pleaded case. I'd said it to his solicitors, who had said it to him, who told me they'd said it to him many times. That's captured in a note. And I said it to Mr. Castles again. It's just a really odd, in that attendance note of a call I had with him where he alleges that I said this, it's really odd for me to say, on the one hand, I don't think you're dishonest, but we're going to ruin you. It just doesn't fit with the tone of it.
it was, though, consistent with the position of the Post Office at that time that they would bring proceedings against him that would have the effect of bankrupting him.
You're asking me about use of specific language. That attendance note shows that I had a call with Mr. Castleton, and in part of the call, I was saying to him that I'd like to be taken to the attendance note so I can remember it better, please. But that attendance note shows that in the call I had with him, I was saying to him, the costs are going to be significant if we win, and that's entirely right. That's very different from saying to somebody, we or Post Office are going to ruin you. It's really different. But it's right to record that I was saying to him that the costs are going to be significant. Whether, I don't want to speculate on what his mind was saying to himself as I said that, because that would be my opinion evidence, not evidence of fact. But I'm clear, really clear, that the language I used to Mr. Castleton was not that Post Office would ruin him.
So there's a dispute as to the particular words that were used, but while he was a litigant in person, you did say to him that the costs that will fall against him will be huge. If you would like precision about what I said, or more accuracy, we need to go to the note. Was there any one conversation? Because you're taking us to a particular note. Yeah. Was there any? Sorry, let me look it up in my. No, we can get to it in due course. Okay. But was there only ever one conversation between you and Mr. Castleton? No. So you're focusing on a particular note at a particular point in time. I am, because that's when. I think he has said something like, Mr. Dilley called me after such and such a date, and I was trying to find whenabouts by reference to comments he had made that we could have had this conversation. But the other point you just made is, I think you might have been made, is were these comments only made to Mr. Castleton? During the course of 2006, we had on more than one occasion told Mr. Castleton's solicitors, he had solicitors for the vast majority of the case, we told Mr. Castleton's solicitors that the costs of going to trial would exceed £200,000. So they knew. And that was a matter that you specifically brought up in conversation with him in November when he was unrepresented? Yes. Can we look at poll 000696622, please? We're now in September of 2006, 11th of September, and this is after a conference with counsel Richard Morgan in counsel's chambers. The main purpose of the conference was to meet 4 of the key witnesses to go over their draft statements with him. I'll return to this particular attendance note because it's quite significant in relation to a number of different witnesses, but could we just have a look at the bottom of page 5, please? So we're now in September of 2006 with the trial approaching. At the bottom, there's a meeting with Mandy Talbot. Mandy Talbot said the difficulty is this has almost become a test case in spite of itself. The Post Office, other solicitors' cases are waiting and watching on this. So at that point in time, was there significant pressure coming from the Post Office in order to succeed in this particular case? I don't recall Mandy Talbot calling in any conversations applying pressure on us. We wanted, as you do with any client, to do your best by them within, of course, the rules of the court and your professional ethics rules. But and so in an adversarial system, it is my absolute duty to act in their best interest. But I don't recall Mandy saying to me, Stephen, you've absolutely got to win this, or anything like this. But she did say it's become a test case in spite of itself. That's the language that she used, and it did have the potential at one time to have become a test case. It ultimately didn't become a test case because Mr. Castleton did not produce any IT evidence. So it just became a case in the end that reconfirmed old law. Are you not aware of the Post Office in any case having brought the Lee Castleton case to the court's attention in order to support the robustness or otherwise of the Horizon system?
I can only speak to the cases in which I was involved, and I have set them out in my statement. I think what it's fair to say, or would have been fair to say, in other cases, is that in the case involving Mr. Castleton, Anne Chambers of Fujitsu had taken a call, and she'd had a look at the system, and what she had said to us is that she'd been unable to find anything wrong with it. Make of that what you will, but her comments were confined to this case. So you could say, well, we've had a look at it and we can't find anything wrong with it. Yes, but in this case. And I've been clear in my statement that when I was looking at issues, whether there were issues with the Horizon system, and considering the points that Mr. Castleton's solicitors were putting on his behalf to us, I was interested really in whether there were issues at his branch.
We'll get to that in due course, and we'll get to the words in Ms. Chambers' statement. You've said that she made clear that the system check was only in this case. Do you think you made that sufficiently clear to the court in the Lee Castleton case?
Well, look, you've got the transcript of evidence. I
don't think we've got a transcript.
Sorry.
We've got some rough notes.
I apologise. You've got my handwritten notes. You've got a transcript of the transcripts that we've been able to locate of certain of the witnesses' evidence. The transcripts, I have to say, some of the sound quality recording wasn't good, but you've also got our typed note. And my recollection, albeit distant now, was that, yes, that was made clear.
Thank you. We're now going to the 10th of November 2006, so around the period in which you've said that you were speaking to Mr. Castleton. Can we look at poll 000697779, please? This is an email from yourself to Mandy Talbot, 10th of November 2006. And it's over the page, please. D. Even if the Post Office wins and is awarded its costs without a capping order, its costs would be assessed, and on assessment, the Post Office may be awarded 60 to 70% of its costs. This could mean that the irrecoverable element of just those costs that are incurred between now and the end of the trial could easily be around £40,000. This would, I think it must mean this would be, this would more than cancel out any gain of the extra £3,500 the Post Office might make if it gets judgment. Of course, balanced against this is that there would be a significant commercial advantage to the Post Office to having a reasoned judgment in its favour. It would send out a clear message to other sub-postmasters.
Can you just scroll up to the date of that, please?
Absolutely. We're quite late on, quite close to trial now, the 10th of November 2006. The trial was in December.
It was.
Yes. Similar time to the period in which you were speaking to Mr. Castleton, it was very clear to you and to Miss Talbot that although you are unlikely to receive your costs back, there would be a significant commercial advantage to the Post Office. So at that time, you knew that there were a number of other cases that were challenging or potentially challenging the Horizon system.
I certainly knew there were two.
And it was important at that stage, you say it wasn't ultimately, but at that stage it was important for the Post Office to get a good precedent in order to avoid other claims that were challenging Horizon from succeeding.
Precedent's a really interesting word because we all use it in different ways. The way lawyers and barristers and judges will understand the word precedent is almost certainly a legally binding precedent, a case law precedent. Okay? Within law firms, that use of the word exists, but there's another usage as well. We talk about precedents in the sense of know-how, in a much wider sense. So, Stephen, could you give me a precedent, particulars of claim, or what, in looser language, what sort of knowledge do we get from that case? It's a looser language of the word precedent. In this case, we didn't know until quite late on that Mr. Castleton would not be serving expert evidence. We were robustly defending what I believe that Fujitsu believed and Post Office believed to be a good system. And we were ready to meet the case that didn't come. And there was a PTR, a pre-trial review in November, and the date will be absolutely in my statement. And it was only then where, because Mr. Castleton had had previous opportunities to serve expert evidence and hadn't, that the judge decided to debar him from doing so. So we didn't know until quite late on, relative to the trial, that the case we were prepared to meet, if it did come, would come.
You've spoken about different interpretations of the word precedent. I mean, it's quite clear in that very final sentence that the precedent that the Post Office was hoping for was a clear message to other sub-postmasters, not to challenge Horizon.
I think that's right. So what I mean by that and don't mean by that, I don't mean a legally binding case that sets out clear rules for whether Horizon is good or bad, because it only looked at Horizon in Mr. Castleton's case, and there was no CPR Part 35 expert report into Horizon. But it did send out a commercial message that Post Office were prepared to defend the system, and you're absolutely right about that.
Even if the effect of that would be to ruin Mr. Castleton.
Well, Post Office were aware of the risk that they would not be able to enforce their judgment.
And this continues after judgment as well. Perhaps we can look in May 2009. Poll 000, sorry, it must be May 2006. Poll 0007027. It does say 2009, actually. If we scroll down to the bottom, I'm not sure why it says 2009. There's a message from yourself to Mandy Talbot, and this is talking about the Castleton's case. It relates to the bankruptcy proceedings, etc. Mm-hmm. So that explains perhaps why it's a few years down the line. And you say there at the bottom, it's frustrating that there is no financial recovery in this instance, although we knew that the prospects were slim, particularly after he was made bankrupt. Post Office Limited's main goal in pursuing Mr. Castleton was achieved in that we had a good judgment precedent which helps us to defend the Horizon system. So although your evidence was that ultimately it wasn't really about the Horizon system, the Post Office and yourself seem to have very much seen it as a judgment precedent that helps to defend the Horizon system.
I don't now agree with the comment I made in that second sentence there, because when you step back and look at the judgment, all it did was reconfirmed old law in terms of a legally binding precedent. And so my language there was broader, and I was trying really, I think, in that email to remind Mandy of the of their goal in pursuing Mr. Castleton. I might have more accurately have written that something like what you've already showed me, Post Office were willing to demonstrate that they were willing to defend the Horizon system. In terms of precedent, though, by reconfirming that old law, which includes, which was all about a case called Shaw and Picton from the 1900s, insofar as that was concerned, I do think that could have been helpful as a precedent, but that concerned accountancy principles rather than the Horizon system.
Putting aside legal niceties as to the definition of a precedent, this statement from you makes very clear that Post Office's main goal was to defend the Horizon system. Do you accept that?
I think that their main goal changed during the course of the litigation, but that by certainly well before the end of the litigation, they wanted to show that they were willing to defend the Horizon system. But I think if that's where the analysis ends, it misses some really important points.
Do you think it was fair for the Post Office to bankrupt somebody in order to defend the Horizon system?
Post Office didn't bankrupt Mr. Castleton.
Do you think it was fair for the Post Office to engage in legal proceedings against Mr. Castleton in a case in which he raised significant issues with the Horizon system and resulted in his bankruptcy in order to defend the Horizon system?
Post Office didn't commence the claim against Mr. Castleton with a view to defending the Horizon system. Post Office commenced the claim against Mr. Castleton to recover a debt. He pursued them. He, in return, issued a counterclaim for £250,000. We wrote to his solicitors and said, look, are you sure you've suffered £250,000 loss? And they wrote back to us reasonably late on and insisted that he did have that claim, that he had suffered that loss. And once they'd issued their claim, once he'd issued any claim, it will either settle or go to trial. And once they'd issued that claim, Post Office had no choice but to go to trial or to settle. That's the only way for it to end. And they tried really, really hard to settle the case. And I do have one regret, actually, in the case. You were asking me about that earlier, and that is that we were unable to settle it.
The impression that's given in your statement and in some of your evidence this morning is that the case wasn't really about the Horizon system, that it was a neat little legal argument about accounts and the signing of accounts. Do you accept that the intention in this case, through the documents that I've shown you this morning, was indeed to defend the Horizon system and to avoid further litigation in relation to the Horizon system?
I think that the Post Office, as I say, they didn't have any choice. They could not have voluntarily ended this litigation. And so their motives in some ways are entirely academic because they didn't have control over the end point of this litigation. I think perhaps the irony of this case is because no expert evidence was served in relation to the Fujitsu Horizon system, because no evidence was served in the end, although they were ready to meet the case, it didn't become about Horizon. Of course, Horizon issues were discussed in the trial. You had Anne Chambers give evidence, for example, about what she found, but it didn't become about that. It became about accounts. And you talk about it in a neat little way, as though it wasn't a substantive point. It's a really, really super important point. By the end of the trial, Richard Morgan, the barrister for Post Office in the case, by the end of the trial, he was all over the numbers. I don't know, of course, what I will remember, but he was all over the numbers. And by the end of the trial, what he'd done, he's got all the primary accounting documents, and reconciled them to the cash accounts. So if we'd have done, again, a taking of account, it would have come to the same result. And Mr. Castleton confirmed that in evidence. So in the end, the reversal of the burden of proof and that, yes, it was helpful. I won't say it didn't matter, but it sort of didn't matter because we could do it. So we proved this case irrespective of the Horizon system. And I've talked in my statement of what I would have expected to have seen based on my understanding of what witnesses were telling me had there been an issue with the Horizon system. And that is where there was a mismatch between what Horizon was saying and the paperwork. I would have expected an error notice to have been generated. Not I would have expected, but that's what the witnesses were telling me because, it wasn't my evidence. But the really interesting thing in Mr. Castleton's case is I think there are only about 15 error notices generated. If the computer system changed what he or his assistant typed into it, you would expect there to have been loads of error notices, and there weren't.
Mr. Dilley, how on earth could you know that, though? I mean, are you an expert in the Horizon system?
I'm a really important point that I make in my statement is the only thing that I can tell anybody about this now is from what people have told me. So this is my secondary evidence, if you like. This is my evidence of their evidence.
But, I mean, you're in some way suggesting that, as a matter of fact, that is what would happen. But in fact, what you're saying is you're just simply regurgitating what you've been told by others.
It was my belief, by what I was told from a number of the witnesses, that would happen. And the error notice system was nothing to do with Horizon or Fujitsu. Nothing to do with that. So this case was brought on the basis of physical paper accounts, agnostic of the Horizon system. And that's why, in some ways, it's an odd case to be looking at.
Mr. Dilley, I'll ask you one last time about this final sentence here. Post Office Limited's main goal in pursuing Mr. Castleton was achieved in that we had a good judgment precedent which helps us to defend the Horizon system. Was the main goal of the Post Office in that case to defend the Horizon system?
They didn't have one consistent goal throughout the life of the case, but it is reasonable to say that partway through the case, certainly we'd advised them, and you've taken us to my advice, rightly, to my advice. They believed that the starting goal of a recovery of a debt wasn't going to be achieved. And so what they wanted to show is that if the Horizon system was challenged, they were willing to meet that challenge. As I say, in the end, the irony was the case didn't come on the IT. Notwithstanding what I say there, the case did not come on the IT because the IT expert evidence was not produced. And that's the somewhat irony. There was the case in the end was based on paper accounts.
I said I'll only ask once, but perhaps I'll take it slightly differently. You've already given evidence about how consistent your paperwork, your notes are with what you actually did at the time. Your note here clearly says that Post Office's main goal was defending the Horizon system. Do you accept that that was, in fact, their main goal?
It became a goal. It became their main goal that they would be willing to litigate where sub-postmasters, and in this case one sub-postmaster was making an allegation about the system because for all the documents you've rightly taken me to this morning, they were willing to have litigate to send the message that they would stand firm. And that's what these documents show.
Mr. Dilley, I've got 2 questions about that sentence, which I hope will resolve this issue. First of all, is that sentence accurate? Secondly, if it is not, why did you write it?
I don't think it is as accurate as I would have liked it to have been rereading that now. I think I was simplifying in a way what Post Office were doing. And
so what should you have written?
I should have said something like, Post Office's main goal in pursuing Mr. Castleton was achieved in that we showed the world, if you like, you were willing to defend allegations about the Horizon system. It also set a useful precedent insofar as it renewed the authority, the old authority in Shaw and Picton. That would have been a bit wordy, but it would have been more precise.
When Miss Talbot received that communication from you, did she write back saying, hang on, you got it wrong, that wasn't our main objective?
I don't recall, but it's entirely possible you've got that a response.
No, I make it clear, Mr. Lilly, I don't know the answer to that question. I'm just asking whether you know.
I don't, but the file might tell us.
All right, thank you.
Thank you, sir. Shall we take our mid-morning break until 11:30?
Yeah, fine.
Thank you very much.
Sorry, what time?
Just after 11:30.
Yeah, that's fine.
Thank you. So can you see and hear me?
Yes, I can, thank you.
Thank you very much. Mr. Dilley, we'll move on to the topic of disclosure, something that you wanted to talk about. Can we look at poll 00082222, and that is the defence and counterclaim from Mr. Castleton. I took you to this much earlier today, and I took you to paragraph 5, that's over the page, and also paragraph 9. And the point that was made was that the Horizon system was certainly front and centre of Mr. Castleton's defence and counterclaim. It was a broad attack on the Horizon system. Can we look at poll 00069298, please? This is a response to a request for further information. So for those who aren't aware of the process, the Post Office makes a request for further information, and a defendant to proceedings will respond in the way they have here, providing that information. Can you see that on your screen in front of you?
Yes, I can.
Yes, and is that a correct summary of the process?
Yes, it is.
Yes. Can we scroll down, please? This response is dated the 10th of April 2006. Now, the wording there is the Post Office's wording in that it sets out what the request from the Post Office was to Mr. Castleton. Can you see that? There's no need to look at hard copy documents. They're all coming up in front of you.
Thank you.
Thank you.
Yes, I can.
Yes. Paragraph 1.1, you've asked, or the Post Office has asked Mr. Castleton to please state precisely the full nature and extent of the problems that the defendant alleges he encountered with the Horizon system and on what occasions he encountered them. 1.2, how and why each of the alleged problems with the Horizon system meant that the losses in question were allegedly theoretical rather than real.
Yes.
And if we go over the page, we'll see his reply to that request for further information.
Yes.
He sets out there a number of problems that he said he encountered with the Horizon system.
He does.
If we look at one, he says, not communicating properly. I think if we look down that paragraph, it says the defendant believes that periodically, several times throughout a day's trading, the base unit would then transmit data input both to it and through the node unit onwards to the central station. On occasions too numerous to recall, during the period in question, the defendant told the claimant that he considered that the two units were not communicating with each other properly. The next problem that he encountered, screen freezing.
Yes.
If we look at the last sentence there, this problem was a regular occurrence and happened approximately weekly during the period in question.
Yes.
Over the page, blank screen. The display of one or other or both of the terminals would suddenly go blank before returning to the sales screen. This problem occurred approximately monthly during the period in question.
Yes.
Next one, card swipe not reading.
Yes.
Next one, rolling over cash figures. The
Yes.
defendant believes that the Horizon system rolled over cash figures in the weekly cash flow figure, a report that can be produced, also known by the claimant as on-hand cash handling or ONCH, giving a figure that was 4 to 5 times as big as the actual cash declaration for that day.
Yeah.
If we scroll down, at the end of that paragraph, it says, on average, the figure given by the system was incorrect on at least one occasion each week, although previously, prior to the defendant being aware of the facility to print the figures, Ms. Train had noticed that the figure was incorrect more frequently, often several times each week. The next problem he identified, lost transactions. The Horizon system would lose, i.e. fail to record transactions which the defendant knew he had entered onto the system.
Yes.
Can we scroll down over to the next page, please? And Mr. Castleton says here at 1.2, how and why each of the problems experienced by the defendant with the Horizon system means that the alleged losses in question were theoretical rather than real is an issue that will require disclosure from the claimant for the period in question, in particular as to the correct operation of the Horizon system software, including any modifications or upgrades, and the correct operation of the hardware maintained by Fujitsu services, including any replacement equipment, together with expert evidence both in the fields of information technology and accountancy.
Yes, he does.
And then, without prejudice to that, he provides a response.
Can maybe just go down and quickly look at the remainder of the response? Thank you.
Thank you. Can we look at LCAS 0000354, please? This is the disclosure list. It's dated the 18th of May 2006, so a month after that response to the request for information. Many of the complaints in Mr. Castleton's request for information that are familiar to the inquiry, is there any detail in the list that follows of any of those complaints, of any investigations having been conducted with Fujitsu, for example, to identify wider problems with the Horizon system? Could we scroll down?
Yeah, have a look. You're really testing my memory, but please take me to it.
Okay.
Yeah, can we go on to the list which was attached, please? No, not that one. Keep going. Okay. Just keep scrolling down. Yeah, keep scrolling down. Can we go on to the next page, please? We can just keep going through this list. This is helpful, thank you. can just slow down now, please. Okay, if we go on to the next page, thank you. Okay, that's fine. Thank you.
So having looked at that list, I think you had a smile on your face.
Sorry, I forgot the question. Can you put the question?
Is there disclosure in that list of, for example, investigations having taken place in relation to those kinds of problems in the Horizon system?
Gosh, that would require me to remember what all of those documents meant, and I don't. But what I can see the list does include is Fujitsu product codes, transaction logs, which is, my understanding, what I was told is that was the line-by-line IT record of each transaction processed in a branch. An events log, which is a record of events on the Horizon system, such as logging on, logging off, printing reports, everything that happens on the system. Overnight cache holdings. I don't know if we saw a mention of that in the Part 18 response that you took us to 5 minutes ago. Horizon system help desk logs and NSBC call logs. In the Horizon system help desk logs, I would imagine I haven't got them in front of me, but if they're in the pack, we could go to them. I would imagine in the Horizon system help desk log, which I think was the second tier of the help desk, as I recall it, there would have been evidence of or information about Mr. Castleton calling the Horizon system help desk and what they did, I think, to look into it. But it is also fair to say, for completeness, that in this list of documents, it doesn't contain the entirety of Post Office's disclosure, because after this list was served, Mr. Castleton's solicitors asked, and when we prepared this list, I believed at the time that this was a thorough list, and I still believe that, and I believe Post Office carried out a reasonable search. But it is fair to say, and I must say for completeness, this wasn't the entirety of the information supplied to Mr. Castleton and his team.
Well, at this point in time, this was the disclosure list that was provided to Mr. Castleton.
Yes, it was.
May 2006.
Yes, it was.
And that followed his response to the request for information.
Yes, that's right.
Now, this isn't a law exam, but what do you understand the tests for inclusion in that list to have been, broadly?
Yeah, so Post Office's duty, I've set it out from the rules in my statement, so you've got it word for word, was to carry out a reasonable search for documents that could help or harm its case or Mr. Castleton's case. My belief at the time this list was prepared is that they had done a thorough job.
The test includes material that would adversely affect the Post Office's case.
It absolutely does, that's right.
And it includes material that would support Mr. Castleton's case.
That's correct. And when you have to take into account four factors that are relevant to the reasonableness of a search, and they include the number of the documents involved, the nature and complexity of the proceedings, the ease and expense of retrieval of any particular document, and the significance of any document which is likely to be located during the search.
Given the centrality of the Horizon system to Mr. Castleton's own case, do you think that was sufficient?
At the time, I did.
Do you now consider it to have been insufficient?
Well, I have explained that we prepared a supplemental list of additional documents that we disclosed after this list had been prepared. I would have preferred, had I known about those other documents, to have put them in this list here.
Can you tell us, you may not be able to tell us off the top of your head, perhaps by refreshing your memory from your statement, when you disclosed further documents.
Yeah, I can. Promptly after serving this list, reasonably promptly, Mr. Castleton's solicitors wrote back to me and said, we haven't got the full audit trail we want. And I picked that up with Post Office and tested that with them, and they said, that's what the transaction logs are. So he had got that. But another thing they picked up with me is, for example, they wanted to see software updates. So there was, Mr. Castleton's had a belief, I think, that when Fujitsu released software updates, it could cause problems with his system. And so his solicitors wrote to us and said, well, we want to know, when was this software updated? Perfectly reasonable question on the part of its solicitors, it seems to me. We went back to them promptly with a spreadsheet of the software update so they could know. What we then did later on in the case, because we made various further disclosures, is later on in the case, we pulled those together in a supplemental list that for the most part referred back to disclosure, further disclosure we had then, by the time that supplemental list was prepared, had made.
This list was provided on the 18th of May 2006. Do you think by that stage you were sufficiently on notice that Mr. Castleton's case focused on the entire Horizon system and the reliability of that system?
It's absolutely clear at that case that Mr. Castleton was concerned, very concerned, with the operation of the Horizon system at his branch, yes. What we found it harder to understand, much harder, which is why we served the Part 18 request, is specifics of that, because his defence and counterclaim was, the original defence and counterclaim, he later amended it, was quite broad and high level. And so what we wanted to do is draw out in that Part 18 request more specific so that we could understand what he was saying and focus on the problems that he was putting to us.
And having received that response to your request for further information a month before this list was produced, do you think there is sufficient information in this list relating to all those problems that he identified?
It certainly took us a step further than we had been in. It's absolutely right to record that, and that was useful. When we, however, stood back, even from that list, and reflected on it over the course of a period of time, particularly after I'd gone to see, with a colleague, Mr. Bratt, Fujitsu in June, we were still struggling to understand not what he was saying, because he said what he said in the response, but how that word was said to have caused illusory losses at his branch.
On receiving his response to your request for information, did you put in train inquiries about Horizon terminals not communicating properly, screen freezing, blank screen, card swipe not reading? So you put in train an investigation into each one of those issues, and you disclosed the product of that investigation.
What we did, and it's documented in my statement and the exhibits to it, is even before we got that list, in November, I think it was about November 2005. My date might be wrong, but it was certainly in 2005. We prepared back then a letter to Fujitsu before we had that Part 20 information, and we said, this is a case where this is our claim, this is the defence, there are allegations about the system. We need from you, and that was our thinking at that point in time, an IT expert report into it, and I sent it to a chap at Post Office called Nick Samuel, who doesn't otherwise really feature in the case, and said, can you, I don't know who to speak to at Fujitsu, can you pass that on to them? I didn't get I didn't get any response. I can see in the additional documents in the core bundle, some of which have been passed to me very recently, that Post Office got a response from Fujitsu. When I saw that the other day, I cross-checked it against our correspondence file. I turned the page on it. I couldn't see it anywhere in our file, which led me to believe that we weren't given that response, as far as I can tell. And I can't remember having got a response at that time. So in November, we say, come on, Fujitsu, this person's telling us there's problems with the system. But to my knowledge, we didn't get a response. There's then a call. I'm going to say it was about March, but that date may be wrong. There's then a call we have with Hugh James solicitors, who were at that time looking at the cases of Mr. Bajaj and Mr. Bilku. We have a call and we say, how are we going to get information from Fujitsu? And it was decided on that call we'd have to go and see them. And there was no shortcut to going to see them. And I was to go and see them, and initially with a partner at Hugh James called Mr. Hulbert, although ultimately he sent somebody else. And we went to see them in June, and we put to them.
I'm going to stop you there, because we will get to this period in time. But can you just tell us, where are you in timings now? Where are we?
So when we went to see, we had in about November 2005 said to Fujitsu, we're going to need some information from you. In the spring of 2006, we hadn't got that information, and we thought we need that information from them.
And did you get that information?
In June 2006, I went to see them, and I put to them, by which stage, of course, you're entirely right, we had Mr. Castleton's response to our request. And I put that to them. And we went through it with them, point by point, and tested it with them to understand whether what he was saying would have the effect that he was describing.
And is it your case that despite that taking place after this list had been written, you then subsequently provided all of that information to Mr. Castleton?
We, to the best of my knowledge and belief at the time, we did, save for one document which came out much later. And that document is called a Tivoli event log.
Well, we'll also get to that, but I'm focusing now on, let's say, the 18th of May 2006. Mm-hmm. You've produced this document. I actually want to take you back in time, and let's look at poll 000737739, please. Sorry, 70563. Poll 3070563. Thank you very much. So this is November 2005. This is 6 months before that disclosure list that you were required under the civil procedure rules to provide. It's a letter from Mr. Castleton's solicitors to Bond Pierce. And I'm going to read quite a lot of that letter into the record. They say, we refer to an earlier letter and the November 2005 edition of the Sub-Postmaster magazine. You will see the highlighted section is a letter from a sub-postmaster in Chelmsford complaining of acute problems with the operation of the Horizon computer system and the complete unwillingness on the part of both the Post Office and the Horizon helpline to assist with the problems or even acknowledge that a problem exists. The parallels with our own client's position are striking. Indeed, our client's research shows that the situation in which the sub-postmaster in question finds himself is duplicated amongst a substantial number of other sub-postmasters around the country. We are instructed that your client has been forced to settle claims brought against other sub-postmasters, some of which involve very substantial payments being made to the sub-postmaster, rather than take the matter to trial. Your client then commonly insists on the insertion of a confidentiality clause into the settlement agreement to prevent the sub-postmaster discussing either the dispute or the terms of settlement. One entirely reasonable assumption based on the above is that your client is only too aware that the Horizon system does not perform properly, but that it cannot and will not publicly acknowledge the fact, because to do so would potentially expose it to a wave of claims from sub-postmasters who have been accused of shortfalls and who have made good the alleged losses. To acknowledge the problem would also most cause acute embarrassment to your client and, most likely, a public relations disaster. In short, this is not an isolated incident of problems with Horizon. This is entirely consistent with our client's position since the dispute first arose. Your client flatly refused to countenance that the alleged shortfall could be the result of anything other than user error or even outright fraud on the part of our client or his employees, despite the fact that it knew very well that there are numerous other cases with similar, if not identical, facts around the country. I mean, that's spot on, isn't it, about the situation with Horizon at that time?
My knowledge was actually concerns, the sort of limit at my knowledge concerns two other cases, Mr. Bargeorge and Bilku. If Post Office themselves knew about more than those other cases, then I can't give that evidence because I don't know.
But in November of 2005, you were being told by Mr. Castleton's solicitors that the problem is with the Horizon system, not simply Mr. Castleton's own Horizon terminal.
Yes, but that was not in his pleaded case.
Well, we can go back to his pleaded case. But let me just finish this letter first, because the letter is quite important. If we go over the page, please. They say, in the circumstances, this supports our previously expressed requirement that your client provide full and frank disclosure of the problems that it has experienced with the Horizon system. The claims that it has pursued against other sub-postmasters on the basis of alleged shortfalls and the outcome of those claims. We shall expect your client to comply with its disclosure obligations in this regard as and when these proceedings move on to service of the list of documents. So this was November 2005. We've looked at the list of documents. Is it fair to say that in that list of documents there was no such disclosure of problems with the Horizon system that have been experienced by the Post Office?
No, it's not fair to say that, because in the call logs to which I have referred, they demonstrate Mr. Castleton trying to contact two different help desks and raising issues with the system. But it would be fair to say, if this is your question, that our disclosure didn't relate to other branches. That would be absolutely right to say.
And that your investigations didn't relate to other branches?
Correct.
Despite the fact that, as we've established, the Horizon system was front and centre of this case.
Well, I was absolutely concerned to investigate the operation of the Horizon system at Mr. Castleton's branch. I've explained, this question has been put to me in evidence, and I've worked through it fully. I don't think I can add to it in oral submissions today, but I've explained how we approached this. We looked at the cost of, we went away after I got this letter, and you're right to say it's a significant letter. We went away and looked at the cost of getting information about other branches, and we were told it would take a certain amount of time and cost a certain amount of money, but really...
£2,000 to £3,000.
Yeah, but the other point is Can you just flick to the...
We'll go to
Can you
that.
just flick back a page? The other point I think they were saying here, just scroll down, please. The other point I think they were, as I understand it, they were saying they wanted... Can you please maybe just scroll down a little bit more? And if we just go on to the next page again. Yeah. So look, in this paragraph here, what I understood Mr. Castleton's solicitors to be talking about is one, disclosure in relation to any problems it's experienced with Horizon system, and B, the claims it has pursued against other sub-postmasters on the basis of alleged shortfall and the outcome of those claims, which may or may not, in that instance, relate to problems with the Horizon system. Do you see that? That's how I'd understood it at the time. And I just thought that was super broad. Super broad. And way beyond Post Office's disclosure duties to carry out a reasonable search. Way beyond.
We've spent much of this morning looking at how the Post Office saw defending the Horizon system as a main part of this case.
Mm-hmm.
Do you not think that disclosure about wider problems in the Horizon system would have assisted Mr. Castleton's case or undermined the case for the Post Office?
You're asking me to speculate on what such disclosure would have revealed, but where I come back to in the case against Mr. Castleton is, and so that's sort of a what-if speculation, but where I come back to in the case against Mr. Castleton is this was a case that in the end, whilst absolutely, he said, as we've seen all morning, there are problems with the system, is that what the case was decided upon was agnostic of the Horizon system. It was based upon physical records, and we knew that we had the underlying primary accounting documents that matched the cash accounts. So if the system had been causing illusory losses, there would have been this mismatch.
Mr. Dilley, that was your case. That was the Post Office's case. It was Mr. Castleton's case that there were problems with their overall Horizon system. Was it not right to afford him the opportunity to have disclosure of wider problems with the Horizon system?
I stand by what I've said. I understand the point you're putting, and I understand you have to put the point, of course you do. But I stand by what I said in my evidence, and I absolutely believe that Post Office met its duty of carrying out a reasonable search by the criteria in the civil procedure rules.
Can we look at poll 000737739, please? And it's the bottom email that I'd like to start with. This is an email from you to Mandy Talbot, the 11th of November 2005. So that's the day after the letter that I've just drawn to your attention.
That's right.
Was received. You say in the bottom paragraph there, I attach a letter dated 10th of November 2005 from Mr. Castleton's solicitors to Bond Pierce for your information, together with an article from November 2005 edition of the Sub-Postmaster magazine, in which a sub-postmaster in Chelmsford complains of problems with the operation of the Horizon computer system. Other sub-postmasters' problems are, in my view, irrelevant to the issue of whether the Horizon worked for Mr. Castleton, unless there is evidence of widespread problems. Mm-hmm. Mr. Castleton's specific point is that there are widespread problems with Horizon, and accordingly, he should not have been dismissed.
Correct.
So you've identified there that the issue, so far as Mr. Castleton saw it, related to the widespread problems in Horizon.
Yeah, and I was, as I say, the only other issues about which I was made aware, as far as I recall, are in two other branches. At that time, Mr. Mr. Bargearge and Mr. Bilko. And when we put to Post Office, because it's important, of course, you put these points. When we put the points to Post Office, is this system robust? Whenever we put those points, they came back and said that that's what they believed.
Could we scroll up so it'll be the first page? It's a further email from yourself to Mandy Talbot and Cheryl Woodward. You said, Mandy, please can you let me know whether the Post Office has experienced widespread problems with Horizon? So that's the question that you've just referred to.
Yes.
Mr. Castleton's solicitors are seeking disclosure of this sort of information because they agree to mediate. If it would be difficult for you to find out this information, please can you give me an idea of how and why it would be difficult and expensive to retrieve it? For example, perhaps there are no central records. This will give me some ammunition to go back to Mr. Castleton's solicitors to explain why the Post Office does not feel it is appropriate to disclose it and to try to persuade them to mediate sooner rather than later.
And that led, I think, to either a call or an email exchange with a chap at Post Office called Dave Hulbert, to which I've referred.
You're there seeking ammunition to try and bat away a disclosure request.
I thought the disclosure request from Mr. Castleton's solicitors at the time was far too wide. But it is also fair to say that in a lot of litigation, you do have an issue where claimant solicitors want as wide a disclosure as possible. And to my mind, what they were seeking was miles too wide. It wasn't just, you remember from the letter, issues with Horizon. It was any litigation with any postmaster.
So at this stage...
What I did think, though, would be relevant is if there were issues at his branch.
At this stage, November 2005, you didn't have instructions from the Post Office yet to say that it was too onerous. It was your view that it was too onerous, and you seem to be asking the Post Office there to give you some ammunition to bat it away.
Gosh, it's difficult to be definitive about that, but I think when I saw, with the distance of time, but I think when I saw their letter, I thought, yeah, this is much too wide. Not a bit too wide, but miles too wide. That was my view based on the view that I genuinely held, based on the civil procedure rules, my understanding of them, the way Mr. Castleton was putting his defence at the time.
If you had known at the time that there were a large number of challenges bubbling away and bubbling up, do you think you might have taken a different approach? Challenges about Horizon?
Gosh, that's certainly a good question that I would want to reflect on, because I do say if there are widespread issues, it would have been something I would have had to have really thought hard about. But the ones that I recall being told about is that there were two.
So you recall being told about two. Mm-hmm. If you had been told about a larger number, do you think that that would have encouraged you to make much wider investigations into the Horizon system?
If Post Office had said to me, where, I don't know whether this is true, I'm going to pluck figures out of thin air. I knew at the time that there were thousands of Post Office branches, and I've looked back for the purpose of this statement, and we've got some records from Parliament, from a Post Office document submitted to Parliament, that at this time there were about 14,000. Okay, that's loads of Post Office branches up and down the country. If I had been made aware that there had been, for example, thousands and thousands and thousands of people saying that their computer system was wrong, it was causing illusory losses, you'd have had to have thought much harder about all sorts of things, but including what your duty of disclosure was and the scope of it.
So the example you've given is thousands and thousands and thousands. If there were thousands and thousands and thousands, would you have disclosed wider problems with the Horizon system, if they existed, if you had searched for them?
I think that is much more likely.
Hundreds?
What are hundreds as a percentage of 14,000 branches?
So you would have taken an arithmetical calculation?
No, I don't. It's really, these are what-if questions. You have to make decisions. The beauty now is we have the benefit of knowledge some 17, 18 years later. At the time, you have to do the best with the information you are given. And what Mandy, I certainly don't recall this, and I believe I absolutely would recall this. Mandy didn't come back to me and say, hi, we've got loads of problems with Horizon, Stephen. And I don't think, well, she will have to give evidence about what she was aware, but in relation to one particular problem, which Mr. Castleton told us about late on, she emails me and said to me that this came as a bolt out of the blue, and that's the language in her email.
We know much further down the line that the Bates litigation, for example, there were 555 claimants. Mm-hmm. If there was a significant action like that afoot, would that have prompted you to make wider inquiries?
If there had been a class action pursued by 550, I think you said, ish, sub-postmasters, your disclosure duties would have to be looked at very differently.
Can we please look at poll 000704996, please? And it's the bottom email. 21st of November 2005, so very soon after. Mm-hmm. An email from Tom Breezer to yourself and others. The very last line on that page. Mm-hmm. Hugh James are currently trying to contain an embryonic and not yet issued class action over the page relating to the Horizon system. A judgment in relation to it, even a default, is currently very bad news for Royal Mail. Isn't that an example of a class action that is happening or in its embryonic stages, which might have prompted you to rethink your disclosure obligations?
I understand the purpose of the question, you must put it, but when we probed with Mandy what that was, our understanding was really that she was talking about Bargearge and Bilko, and I don't wish to criticise Mandy Toll, but she did have a turn of phrase that wasn't always, I came to learn, that wasn't always accurate, and the only two cases that came to my attention when we dug on this are those two. If she was aware of more cases, 550 cases, she never told me, and she never told my firm.
Wouldn't the mention of a class action make you think about your disclosure obligations in this particular case?
I agree with you. The mention of class action caused us to have a conversation about what this was about. But actually, there was two other cases. So yeah, you're right. You do have to think about it. I mean, disclosure hadn't come up at that point in time, but you do have to think about it. You do have to think ahead. But when we tested that with her, there was Mr. Bargearge and Mr. Bilko.
In November 2005, so you've received a letter, I think, from Mr. Castleton's solicitors about wider problems. You've received information from Andy Talbot talking about a not yet issued class action. Were you not getting concerned at that time about getting together sufficient information to disclose to Mr. Castleton in respect of the core of his claim?
I think it's fair to say when I first inherited the case, a lot of the focus was on setting aside a default judgment which Mr. Castleton had obtained. But I do recall from refreshing my memory on the file that I looked at pre-action disclosure which had been done. And at that point in time, as I record in my statement, I did have concerns about pre-action disclosure which had been done and whether it could have been more extensive.
Do you see this as a missed opportunity to look further into the Horizon system?
It was an opportunity that was probed with Mandy by asking her what it was about. And can you scroll up, please, onto the preceding page? And just to scroll up to the... yeah, there we go. So this email exchange, this internal email exchange between Tom Beezer, who was the supervising partner on the case, and myself, was... The context of this was off the back of our discovery that Mr. Castleton had obtained default judgment. And so it's a very, Tom is reporting a conversation he had, so my evidence of it, of course, is secondary. Tom is reporting a conversation that he had with Mandy Talbot. The right thing to do, which we did, was to probe and understand that and get under the skin of it, which we did. And what we were told is that there are issues with Mr. Bargearge and Mr. Bilku. Now, Mandy may or may not have been aware of more, but that's what we were told. But if that was the extent of what was going on, I think it would have been inaccurate of Mandy to have talked about an embryonic and not yet issued class action, but she was quite dramatic, and I think she was saying this in the context of worrying because a default judgment had been obtained.
Can we scroll down and over the page, please, because there are requests from Mandy. Mandy's made a number of requests that I feel we must comply with. Looking at number 2, that should be sent a full set of proceedings in order and a full set of correspondence from the outset of the matter.
Yeah.
Stephen, this must be done ASAP. Mandy has a meeting on the Horizon matter on Friday this week. She needs this paperwork. Please confirm that the files and appropriate covering letter will be sent in tomorrow's DX. Number 3, due to the matters handled by Hugh James relating to Horizon, so that's the matter we've just been talking about.
Those two matters, yes.
Pardon?
They were handling 2 matters, Mr. Bargearge and Mr. Bilku, separate matters.
Where does it say that?
No, that's what I came to learn.
Well, the wording here is Mandy asked that we speak to them to ensure we're all pulling in the same direction. This is even more important given the threatened class action. She again repeats the word class action.
It is.
Who makes this call is partly dictated by how many Horizon-related cases we currently have. More on this below. Number 4, Mandy asks that we never issue proceedings on a claim based on Horizon evidence or connected in any way to Horizon without her specific consent. Please let everyone know this. Is this, do we see the post office trying to exert control over the conduct of Horizon-based litigation, so far as you could tell at that time?
Yes.
Number 5, Mandy wants a report on how many Horizon-based claims we currently handle. Please action with your teams. I will coordinate the response. Can we please now go to poll 000700492? We're now on the 22nd of November 2005. And if we look at the bottom email, it's an email to Mandy. Is it from your... No, you're copied in. I think it's from Tom Beezer. Is that correct? And he says at 3, an updated spreadsheet is being prepared listing all Horizon-related cases. From my end, you're aware of Blakey and Patel. So are those the 2 that you were talking about, or where does Bajaj?
No, Bargearge and Bilku.
So
That's what Tom is saying to Mandy Talbot.
So are those the 2 cases, or are there now more than 2 cases?
Well, I mean, this is my evidence of a conversation that somebody else had with Mandy Tolbert, but what that email is saying is, from my end, you are aware of Blakey and Patel. That is not Bajaj and Bilku.
So there is a spreadsheet being prepared of Horizon cases. Now it seems there are at least at a minimum 4, because there are two you mentioned.
Yeah,
plus
correct.
And of course, these are only matters that have reached court proceedings. They aren't a list of, for example, complaints about the Horizon system. They're matters that have actually reached at least the litigation stage, whether it be pre-action or in court.
That's my inference. What I don't know, though, from looking at this, is how do you define Horizon-related matters? For example, do you define that as a case where you're running it based on evidence from the Horizon system? Do you define it as a case where the postmaster or postmistress has said, I don't think Horizon's working very well? So I don't know, looking back on that, what the definition was.
Were those questions you asked at the time?
I just can't recall, but it was just so long ago. I don't now know what was meant by Horizon-related cases. I mean, the Horizon computer system was in every post office branch. So if you took a really expansive view, you could say, well, any litigation must be. But that didn't mean that the litigation that the postmaster said there's a Horizon-based problem, and it didn't necessarily mean that it was pursued in reliance upon Horizon information. So I just can't remember at this stage. I'm sorry.
This is November 2005, so well before that disclosure list in May 2006. You were, by that stage, aware of a spreadsheet relating to Horizon cases, case of Blakey, case of Patel, 2 other cases. You're aware of mention of a embryonic class action. Did that make you think there that it would be reasonable and proportionate to do broader searches into problems with the Horizon system?
So Blakey, Patel, as I say, I don't, they weren't cases that I recall myself working on, and I don't know how we defined Horizon-related issues. Bilker and Bajaj, handled by Hugh James, were the only other 2. 4? No.
Well, there's a spreadsheet. It may not just be 4.
Well, I don't remember seeing the spreadsheet. I might have done, but certainly as I've turned the page on our file relating to Mr. Castleton, I haven't seen it.
Pursuing a claim that was ultimately going to lead to somebody's bankruptcy for the purpose of defending the Horizon system, reading about Horizon-related cases at this time, might it have been worth pressing the post office and Fujitsu a little bit more?
I don't think the case would necessarily have resulted in Mr. Castleton's bankruptcy, even if he could not have afforded to pay the judgment debt. I don't think that was by any stretch set in stone at that point in time. But all I can say, with the knowledge that I had in the time, is that I was more than satisfied, as I've recorded in emails at the time, that and I advised Post Office, well, we must do a thorough job, and I thought they had.
Can we look at poll 000704555, please? We're still in 2005, November 2005, 24th of November. This is an email from yourself to Tom Beezer. I think he was also a solicitor at your firm, is that correct?
He was a partner in the firm who supervised me on this case.
You will recall that one of the questions Mr. Castleton's solicitors have raised is that we should give them wider disclosure of all Horizon-related problems at the Post Office, details of the claims made involving shortfalls and the Horizon system. So it seems as though it was narrowed to details of the claims made involving shortfalls and the Horizon system and the outcome of those claims. This is because they state that there are endemic problems with Horizon. And you say there, this seems like an onerous request. That's consistent with...
I'm summarising that, but I actually think their letter was broader than that. Yeah, it did seem to me, absolutely, it did seem like an onerous request.
And the request here relates to 2 Horizon helplines. Mm-hmm. And you say, calls are not logged by category, or someone would manually have to go through the records of every call logged to tell whether it concerned a Horizon-based problem.
Yeah.
David Hulbert estimated a junior manager would have to do this, and it would take them 3 to 4 weeks to go through 3 to 4 months' worth of call logs, and this would cost the Post Office approximately £2,000 to £3,000. Mm-hmm. Obviously, the time and cost are increased if more than 3 to 4 months' worth of information is needed. How much did the litigation ultimately cost the Post Office?
By the end of the litigation, it was, I think, over £300,000. Although we did not know that it would cost that at that point in time.
Do you think that £2,000 to £3,000 would be so unreasonable, so disproportionate in the context?
In the context of what I knew at the time, yes. And if you look at point 1, Horizon System Helpline, which receives 12 to 15,000 calls per month. This is for technical problems with Horizon. Okay. When I have a computer problem at work, I will ring our IT support desk. That will mostly flush out that I've made a mistake with the computer, and I've done something. So the production of Horizon system, 12 to 15,000 calls a month, I think would have flushed out potentially that sort of issue that I've raised. It may have also flushed out other issues. I don't know, because we didn't go and get it.
So is 12 to 15,000 a large number or a small number?
Of calls, 12 to 15,000 calls a month seems to me to be a large number. But what that note doesn't say, it says for technical problems with Horizon, but as I say, I ring my IT support desk because I think I've got a problem with my computer. When you make the call, it's mostly me.
You described 12 to 15,000 as a large number.
I think so.
Wouldn't that be precisely a reason for investigating the Horizon system further?
I don't think so, no. I think that 12 to 15,000 calls a month isn't telling us that, yes, it's telling us that the sort of postmasters raised issues, but it's not telling us what caused those issues. And as I say, to draw my own analogy, kind of a large amount of the time, it's me. And I don't cast any judgment on the postmasters for this. One thing I took away, if nothing else from this, is this system wasn't the easiest system to use. I remember at trial, we had in the trial bundle a user manual that was 1 or 2 LibreOption folders thick. And if you had a user manual that was 1 or 2 LibreOption folders thick, I think you've got a problem with its usability, if nothing else.
Am I to understand you correctly that 12 to 15,000 is too many to search, but not enough to show that there's a problem with Horizon?
I didn't think that. I think there's 2 issues with this. First of all, I didn't think it would generate relevant information, or it might have flushed out, I suppose, both relevant and irrelevant information, and if you like, drowned Mr. Castleton, because if people are ringing with problems that are caused by themselves, then providing him with information about that is not going to help.
That's a matter for him, though, isn't it? I mean,
One of the
relevant information.
One of the criticisms claimants, when you hear about disclosure being talked about, one of the criticisms claimants sometimes make is, oh, the defendant's absolutely swamped us.
So providing him with relevant information, you said it might flush out relevant information. Providing him with relevant and irrelevant information, in your view, would have been too much for him.
I believe that what was absolutely relevant was the IT at his branch, unless Post Office were telling me there were lots of problems with the system. We have seen them tell me that there are two other people it has come through to that there are issues, and the previous email which you showed me mentioned two different people, but I don't know how Horizon was defined in that, as I've explained.
Absolutely relevant. Is that the test for disclosure? Those are the words you've just used. Absolutely relevant. Is there some sort of qualification on relevance?
I think that searching through 12 to 15,000 calls per month for how long? When's the start date? When's the end date? I think that what would be, you have to factor into account the reasonableness of the search, and the CPR say that includes the number of documents involved. Well, we had 12 to 15,000 calls a month to sort through, and this was a claim that, yes, there was a counterclaim for £250,000, but the claim was for about £26,000. And I thought that the fact that they would have to look at £12,000 to £15,000 a month was a factor that you had to take into account. Because, I mean, it's not what I say, it's what the civil procedure rules say.
How much was the counterclaim at that stage?
It was put at £250,000, and we...
At that stage, November 2005.
I think that it was put that stage, if memory serves me correctly, at £250,000. We thought it was not... We believe that the quantum was materially overstated, as ultimately proved to be the case when we got an amended defence and counterclaim shortly before trial that reduced it to about, I'm going to say, in the region of £11,000.
You have a counterclaim that's worth £250,000 or valued by the defendant at £250,000. You have...
Sorry.
You have a case that we have established was significant for the Post Office in defending the Horizon system. There are documents, 12 to 15,000 calls per month, that you think might flush out relevant information, and you don't think that £2,000 to £3,000 is a cost worth incurring.
Well, you have to bear in mind a number of factors. The number of documents involved, £12,000 to £15,000 per month. 12 to 15,000 documents, calls per month. How many documents does a call generate? I'm imagining each call generates one document. Does it generate more? But I'm assuming that there's 12 to 15,000 documents per month. Over what period? When do you start? When do you end? But yes, the conclusion I came to, or would have come to, is that when bearing in mind the number of documents involved, the nature and complexity of the case, we didn't think it could have been a £250,000 claim, because the contract with him contained a 3-month termination provision for no fault. So I don't think the true value of the claim was £250,000, although it is absolutely right to record that even when put to his solicitors, they said, no, it is, until quite late on where they changed their position. But bearing in mind all the factors that you have to take into account, yeah, I think this would have gone, my view that I held is that this would have gone way beyond.
Mr. Dilley, we started today and I asked you if you had anything to say to Mr. Castleton, and you didn't have any regrets. I mean, looking at this particular issue, do you regret not providing disclosure in relation to those calls?
No. But I didn't say that I didn't have any regrets in this case. I record in my statement that I do regret that we were unable to reach a settlement, but we did try hard to do so. And it's right to record that.
Yes. This is November 2005. May 2006, we have the disclosure list. Can we look after the disclosure list? Poll 000698878. We're now in December 2006, so shortly before the matter goes to trial. Can we go over the page, please? Sorry, if we go slightly above, we can see who it's to and from. It's to Mandy Talbot from Juliet. In fact, sorry, can we start from the very bottom email? Thank you. And Mandy Talbot says to Juliet McFarlane, Juliet, can you drop me a line urgently to let me have your comments about why these cases were dropped if they involved allegations about the Horizon system at all? We need this urgently because we have a civil trial which challenges Horizon on next week. I know there's not a lot of information to identify the cases, but please let me know what you can. And if we look above, we have an answer. Mandy, Thomas is my case. I think that's Huey Noel Thomas whose conviction was subsequently overturned. Are you aware of that?
No.
He was charged with theft of £48,000. He blamed the online banking system, claiming that reports had several transactions showing nil transaction. So you were looking in December, very shortly before the trial, at these different cases. Is that because they were raised by Mr. Castleton himself?
I think so, yes. And when he put specifics to us, we asked Post Office to look at them to see if they were relevant.
So the way that the process worked is you waited for Mr. Castleton to identify cases that the Post Office might be involved in, and then to identify what they involved. In this case, an allegation that there was issues with the transactions.
The question suggests or implies that we didn't give consideration to the issue of other cases on disclosure, and we did. And to the best of my recollection at the time, bearing in mind what the court rules say, we believed that we had more than met our duties or the Post Office had more than met its duties. That's my recollection. But when Mr. Castleton raised specific cases, I thought it was, you want to be thorough. That's not saying we weren't thorough earlier, but if there's information that comes to light that he raises, I wanted to put the point to Post Office, and I thought it was right that we should put the point to Post Office, and we did.
Why was the burden, though, put on Mr. Castleton to identify cases that might involve disputes about the Horizon system?
We weren't putting the burden on Mr. Castleton.
Was this
But he did raise them, and when he raised them, it was right to test it with Post Office.
Was this a case that the Post Office had made you aware of before December 2006?
No.
Can we please look at poll 000700175, please? And we're looking at the second page. A bit further down, please. This is an email to Leslie Joyce. And it says, "Hi, Leslie. The last the last one this week, and I am on leave for a week, there are 2 visits that have direct reference to losses, although some from earlier years allude to problems with balancing, and that is a case of Ferry Hill. Was that a new case to you?
Yes.
Can we please look at poll 000700126? This is the attendance note that I think you've already you alluded to earlier. 6th of December 2006, very close to trial. Mandy Talbot saying that today's news about problems with the Horizon system at the Falkirk branch had come as a bolt from the blue, that she had known nothing about it, and that Fujitsu did not give any indication. Could we get a Fujitsu witness to give evidence? Richard Morgan saying that we need a Fujitsu witness to identify why there was a problem, but Lee Castleton's was not. Was there a latent defect or software problem from a subsequent update or a hardware problem specific to that branch? Richard Morgan saying that he was concerned about whether we have to give disclosure of this fact. He thought probably yes, but wanted to find out if the judge thought it was relevant.
That's right.
Richard Morgan was prepared to put off a decision on this until after his opening. Richard Morgan asked Mandy Talbot to get some definitive answers from Fujitsu. Richard Morgan saying that we may finish in court by lunchtime tomorrow. So there you have become aware of a problem at the Calendar Square branch.
Yes, that's right.
And that is one of the bugs, errors or defects that is in the Bates and others judgment. I don't know if you're aware of that. Can we look at poll 000700131? If we scroll down to the bottom of the page, it's an email from Mandy Talbot to Lynn Fallowfield. Lynn, further to our chat, can you advise what are the names of the postmasters and addresses of the branches, if possible, of the following FAD codes? In February of this year, you wrote to Gary Blackburn, and he wrote to Sean Turner, and then Sandra McKay about these branches, which had apparently registered complaints about the Horizon systems. That's 1, 2, 3, 4 branches. Fujitsu have told us that in respect of the Calendar Square, that there was a problem when stock was transferred from one stock unit to another, but this would only apply when there was more than one stock unit, than one position at the counter. Did you find out what the problems were at the other branches and what Poll and the Post Office and Fujitsu do to correct them? I mean, we're now in 6th of December 2006. The impression that's given is it's quite a lot of last-minute scrabbling about in relation to a number of different complaints and problems with the Horizon system. Do you agree with that?
I have to set that question in its context. Firstly, when we did disclosure back in May time, we didn't get Mr. Castleton's disclosure, and it was, it felt a little bit like, in some of it, going to the dentist and pulling teeth. I had to pull it out over a long period of time. Late disclosure came in, and in civil litigation, litigants are under an ongoing duty of disclosure. Mr. Castleton, yes, you do disclosure at a moment in time, but you're also under a duty to keep it under review. Mr. Castleton raised these cases, brought them to our attention. When they were brought to our attention late, I can't help that. What we did do is put them to Post Office. The issue around other branches was put to the trial judge, and he made a ruling on it.
The suggestion seems to be that Mr. Castleton was disclosing matters late. These were bugs, errors or defects, or allegations of bugs, errors and defects at Post Office branches. Why on earth would the burden have been on him to identify bugs, errors and defects?
Well, both parties have disclosure duties to provide information which helps their case or might harm their case or the other person. So both parties have duties, and I've explained how we approach that insofar as post officers' duties were concerned. But it wouldn't be right to say that the only party that has a duty is post office, but it did, of course, have its duty.
How was that going to work, though? I mean, was he expected to go up and down the country to different post offices, asking them if they had bugs, errors or defects, if they had Horizon problems?
I didn't advise Mr. Castleton in relation to how he approached disclosure to comply with his duties.
Do you think the suggestion that he failed in his duty of disclosure relating to Calendar Square is a little ridiculous?
I don't know when Calendar Square came to his attention. I do know actually when it came out, it turned out to be, it was discussed in the trial, and it actually turned out to be, in this instance, a complete red herring. But it was looked at, and fortuitously, Anne Chambers had looked at it and was able to give evidence about it. Her evidence about it was, number one, it could only happen when there was something called individual stock unit balancing. Mr. Castleton didn't have that in his branch. The way I understand that, to use a metaphor, is his computers, just to use a metaphor, had what I'll call a hive mind. But the Calendar Square problem could only happen, according to Anne Chambers, when there was individual unit stock balancing. The other point, that she made other points about it, including that it happened at more than one site, and that when it happened, it was obvious to Fujitsu.
You described it as a red herring. Horizon was front and centre of Mr. Castleton's case, problems with the Horizon system. Do you still not think that a bug, error or defect of the significance of the Calendar Square problem should have been disclosed to Mr. Castleton far earlier in the case by the Post Office?
No.
So I'm moving on to another topic. I'm happy to start it, or we could take a slightly early lunch. We do have quite a lot to get through today.
Well, if that's the case, I think we'll take an early lunch so that we have breaks at reasonably, reasonable intervals. So let's have lunch now. What time should we start?
So if we start at 1:45.
All right, fine.
Thank you very much.